So the seminar will be on campaign finance regulation. Is it a troublesome area? And so I'll be looking at the ACT experience over my period as Electoral Commissioner in operating the campaign finance laws.
So I'll be discussing Unions New South Wales and New South Wales, or Unions number 2. And it's really about preserving the integrity of the electoral process, and that includes the discourse leading up to elections. And this case really was asking whether it's permissible for third-party campaigners to be regulated and capped at a different amount than major and minor political parties, and if so, to what extent.
So there's a few issues that make campaign finance regulation troublesome at this current time, and one of the biggest ones is that there's quite a big difference between the disclosure thresholds at the Commonwealth levels compared to the disclosure thresholds at, for example, the ACT, but also New South Wales, Queensland, such that it's much easier to avoid disclosure at the federal level than it is at these state and territory levels.
This was more about organisations that were seeking to influence elections without running a candidate. So unions are obviously the most visible of those, but organisations like Get Up, business councils and those kinds of things that are looking to spend money with the view of influencing an election and perhaps privileging a particular candidate without actually formally uniting with that candidate or aligning themselves with a party.
When people are able to donate relatively large sums of money without being able to be disclosed at the federal level, does that actually have an influence on public policy? Does it have an influence on the way in which politicians make their decisions? And I think there are issues that you can point to that are within the meaning of the topic of the seminar, troublesome.